We're going to continue from where we had left off yesterday. We're going to look at the second part of the story. And the second part of the story is basically the relationship between fundamental rights and directive principles. This story or this constitutional evolution has a lot more to do with an ethical idea as much as it has to do with a legal idea. Okay? So let's understand. Let us forget about the law and let's begin our discussion on this subject, on this specific part, with a simple case study. The case study that I am going to use to explain this to you is a borrowed case study. It is not my own original case study. This case study in a more advanced form, and I'm using a simplified version, but this case study in a more advanced form is used by somebody called Michael Sandels. Michael Douglas is an actor. Michael Sandels, who is a Harvard professor of law and ethics. He has an extremely brilliant series on YouTube, called Justice, What is the Right Thing to Do? I will certainly recommend that if you have some time, you watch his series of lectures. They will help you immensely in clearing some foundational concepts of ethics as and when you study ethics. Alright? So let's understand what it is and let's understand exactly what we're going to be doing. Alright? So let's start. The case study is a simplified version of what he uses so that we're able to only fulfill our requirements and our needs as far as the syllabus and the exam is concerned. The case study is a simple one. It is, suppose this is a road and this road either goes a left or goes a right, which means you can either take a left turn or a right turn. You're in a car. You're the only one in the car and you're driving the car, and unfortunately the brakes of the car have failed and the car is at a considerably high speed of 120 kilometers per hour. Alright? 120 kilometers per hour. Now, at the end of the left side of the road, there is one person, and at the end of the right side of the road, there are 6 people. Yes, Jayadri, right? Yes, Jayadri, this was, yes, absolutely. At the end of the left side of the road, you have one person, and at the end of the right side of the road are 6 people. Okay? 6 people. Now, you can either take a left or you can take a right. You cannot go straight. Your only options are either take a left with the one person and either take a right with 6 people. You don't know anything about these people. These total 6 people plus 1 7, you don't know anything about them. They are just individuals to you. You don't know who they are, you don't know what they do, you don't know what their backgrounds are, you don't know what their gender is. Nothing. Nothing at all. You just know that there is one person at the end of one road and 6 at the end of the other. Now you only have two options before you. Option number A. Option number A. You take a left turn and you kill the one person, but you save the 6. And option number B. You take a right and you kill the 6 people, but save the one person. Now, think about it as clearly as you can. In the comment section, tell me what is your option going to be and why. Good, good, very good. Most of you, most of you, most of you have chosen to take a left, cause minimal damage to human life, and because there is no option and only one person is getting killed in option A, so I'm going to kill the one person and save the 6, which seems to be a very, very good way to go about it. Very good, Divyansh. Divyansh, I also have a message from you. I will get back to you today. Right? Very good. Excellent. There are there is one person who's saying I will kill the 6 because these 6 people can try and stop the car and I will get into trouble. And that's a principle of self-preservation. But the right thing to do here is essentially going to be take the left, and the reasons why you should take the left are more important. Not killing six people is because you think they're going to stop you is not the answer. Right. Understood. Good. Now, for most of you, you've decided to, and that's the right option, by the way, you've decided to kill the one person but save the six, because human lives at this particular moment in your life is nothing but a statistical aggregate to you. Because you don't know the backgrounds of these people, then the best thing to do, the best thing to do is to cause minimal damage to people, and the more people you save, the better it is for you, right? Now, this in ethics and moral philosophy, as some of you have rightly pointed out, is a principle called utilitarianism, which is nothing but greater good. Greater good basically means doing what benefits a larger chunk of people. And you would be surprised to note most of the life decisions that we take, most of the decisions that are often taken by families, by industries, by governments internationally, they all conform in some way or another to the principle of utilitarianism. Even if it's a tough decision, but if the tougher decision is helping a larger chunk of people, and if that tougher decision is helping a larger chunk of people at the cost of a smaller chunk of people, then that decision will always be justified. Of course, if I told you that these six people are six pregnant women and this one person is a terrorist, then your answer may be different. And we could have a debate on whether that was the right answer or this is the right answer. But in the given scenario that you have absolutely no clarity on the identity and the backgrounds and the moral nature of these seven people, it is only natural for us to try and save as many as we can. In the modern day world, there are several such decisions that we take on this very simple principle of utilitarianism. For example, you will often hear of governments using unarmed aerial vehicles and then arming them, and they're called drones. India has recently mulled over a drones policy after there was a drone attack at a military base in Jammu and Kashmir just last year. Some of you may be well aware, and some of you might be open to that idea. Now, here is this. If a drone has to be used, and let us say you are the government of a country who's operating a drone, you have received intelligence that in a remote village which has about 100 people, there are about 20 terrorists hiding in that village of 100 people. You know that these 20 terrorists are planning a massive terrorist attack which is going to kill at least 1,000 people all across the country. Now, a drone does not believe in covert warfare. When you fly a drone and you disengage the arms from the drone, the entire village is going to be bombed. Along with the 20 people, there are 80 people who are also going to be dead, and those 80 people, are innocent people. 20 terrorists are going to be dead, no doubt. But those 80 innocents are also going to be dead. So in total, you're killing about 100 people to potentially save the lives of 1,000. From the view of utilitarianism, from the perspective of greater good, this of course is the right thing to do. This of course is something we should be able to consider, right? These were the only two options in the case study, and if I had to force you to choose an option, I am glad to note that most of you have chosen in this case study a simple one, what could have been the correct option, which is this. And based on this principle of greater good, based on this principle of greater good, or this principle of utilitarianism, if you'd like to call it that, is basically the conflict or a decision that has to be taken with respect to fundamental rights versus directive principles. Fundamental rights versus directive principles. Okay. Now, what is interesting to note here is actually this part. See, when we understand this, and we understand this rather clearly, fundamental rights are primarily individualistic. They are individualistic. Your fundamental right has been individually and guaranteed to be protected against the state. We had discussed this in our initial classes as to how fundamental rights are basically violations, are protections against violations of the state. They are negative obligations against the state. Whereas directive principles of state policy are collective in nature. They are collective in nature. They are more community driven. They are more society driven. And therefore, directive principles are supposed to help the people at large, the society at large. And if directive principles are supposed to help the people and help the society at large, and if the government wants to implement a directive principle, there is no obligation, there is no compulsion. But if the government wants to implement a directive principle, wants to enforce a directive principle through a law, through anything else, and in the process of this, okay, in the process of this, if the fundamental rights of a few people are being violated, this is the genesis or the context of what is called fundamental rights versus directive principles. Okay? This is the context to fundamental rights versus directive principles. Are we clear on this? Do we understand this? Is this simple enough? Yes. Do we understand how the conflict arises? Do we understand where the conflict arises from? Yes or no? Yes or no? All right. Excellent. Now, let's understand the evolution of this. Let's understand the broad timeline of this. And let's figure out exactly what happened. How did the codes go about it? And then you'll be able to merge this in the larger diagram that we had discussed yesterday. Right? So let's do a simple diagram. And let us start. The very first case that we are going to refer to, the very first case that we're going to refer to is the state of Madras versus Champakkam case. Okay, this is the very first case within the very first year of the constitution. Okay, so the first development happens here where we refer to the state of Madras versus Champakkam. Now, the state of Madras versus Champakkam, as we know this, is a case of 1950. It's the case of 1950. Okay? In fact, the verdict was finally delivered in 1951. What is very interesting to note is, this is actually India's first ever reservation related case at a time where India did not have any national policy on reservation. In 1950s, we did not have a proper reservation national policy. Now, I'll walk you through the facts of this case so that you understand exactly what it is that we are referring to. Now, this case, because we don't have a national policy on reservation as such, but there was a directive principle under Article 46. If you want to know what Article 46 is, it's basically the promotion of the interests of scheduled caste and scheduled tribes and other communities. I will show the text of the article to you. Promotion of educational and economic interests of scheduled castes, scheduled tribes and other weaker sections. This is a directive principle of state policy, which means if the government wants to, when it wants to, it can implement the provisions of Article 46. It says, the state shall promote with special care the education and the economic interests of the weaker sections of the people, and in particular of the scheduled caste and scheduled tribes, and protect them from social injustice and other forms of exploitation. So, now when we say the government can implement it, it means both the center and the states can implement it when they want to, how they want to, and if they want to, right? So the facts of this case are in relationship with Article 46. I'll run you through the facts. They're actually very simple facts. So let's understand this. In the state of Madras, there were only 4 medical colleges which were run by the government of the state of Madras in 1951. There were only 4 medical colleges run by the government of the state of Madras in 1951. And throughout the state of Madras, there were only 330 seats available for all students to take admission A's. Okay? Now, through a state of Madras order, through an order issued by the government of the state of Madras, reservation is implemented for these 330 seats, not only for the students who were domiciled in Madras, but also for students who are coming to study in Madras from other parts of the country. And as a result, there were essentially a large number of seats that were meant to be reserved. There were about 17 seats that were reserved on a specific criteria, and there were about 12 seats which the states had the discretion to give to any student that the state had the powers to. Right? Understood? Similarly, there were engineering colleges also in Madras, and the total number of seats for engineering colleges in Madras in 1950 were approximately 400. And here also, there were essentially 21 seats reserved for students who were coming from outside, and 12 seats were reserved for students on the discretion of the state. Now, this was an issue because people had a problem with this government order. The problem wasn't with the fact that there were seats. The problem was that there was reservation, and the problem, according to the people at that time, was that there was discretionary reservation. You had an X number of seats available across engineering and medical colleges for students which are coming from outside the state, and a Y number of seats could be given to anybody as per the discretion of the state. People started calling this a communal government order, right? Which was basically looking at dividing this reservation on the basis of some form of religion. Because when the government released the details of this reservation order, it was primarily based on religion, wherein there were seats that were reserved for Brahmins, for non-Brahmins, for Harijans, for Anglo-Indians, for Indian Christians and Muslims, right? And the basic idea was that later on, medical colleges also reserved 20% of their seats in Madras for women, okay? Imagine this is happening in the very first year of India. And this concept of reservation started before the constitution came into force. And after that, after the constitution came into force, this communal order was notified, or this government order was notified on 6th of January 1950, around the same time as the constitution was put into force. Okay. Now, Champakkan Dorai Rajan, that's the full name, actually went and filed an application in the Delhi High Court because he said he belonged to the community of Brahmins, and the seats for Brahmins were already reserved and they were full irrespective of merit. So I was not, according to him, he said, I was not given an opportunity to be able to participate in the admissions of all of this, right? So this was basically these were the facts of the case. Now, the government said, we are doing this because we want to implement Article 46, which is Directive Principles of State Policy. We're doing this because we want to implement Directive Principles of State Policy. This case eventually reached the courts, and the courts then finally and clearly said, nothing doing. The courts declared this communal order as unconstitutional. They said, these are violating your fundamental rights. Your fundamental rights allow you some special provisions with respect to social and educational backwardness, not on the basis of religion. And if you're trying to do this on the basis of religion, you're undermining the very purpose of reservation. So very interestingly, the story of the conciliation between directive principles and fundamental rights, or the conflict between directive principles and fundamental rights, is the story of India's first ever reservation case. Here the Supreme Court very categorically, as clearly as it could, said all fundamental rights are superior to all directive principles, and you must not, under any circumstances, implement a directive principle that violates a fundamental right. And the first development represents a conflicting phase of our discussion on fundamental rights versus directive principles of state policy. Okay. Fundamental rights versus directive principles of state policy. Do we understand this? Is this okay? Yes. Okay. Thank you, Abhishek. Now comes the second case. Very interesting case again. And this case again has something to do with reservation. Okay. So let's understand what this is and where is the problem, and let's figure this out. This case, unlike most cases, is like A versus B. This case is in RE, that is a short form of in reference. In RE stands for in reference. I'll tell you what it means. Okay, the Kerala Education Bill. This is the 1957-58 case. Okay, this is a 1957-58 case, and eventually was decided in 58. So you can write 1958 or 57, both is fine. Now let's understand what is this, what is it that we're talking about. So first things first, on a side note, let me first teach you what is meant by in reference. See, in most cases you would have seen by now, it is usually A versus B, somebody who's going to court, somebody who's defending it, and if you then go on appeal to a higher court, it becomes B versus A. Right? We understand this is simple. But we use in reference in two cases. In two cases. We'll do these powers in detail later on. But the first instance is the president has the powers to refer a matter to the Supreme Court for their opinion. Okay? This is a power given to the president under Article 143, and this is a power of the Supreme Court also to give a legal opinion. This is not a binding legal opinion, but to give a legal opinion, and this is also called the Supreme Court's advisory jurisdiction. Okay? Now, when we do this in detail, I will tell you that there are two kinds of advisory jurisdictions. One, where the Supreme Court necessarily has to reply to the president, and two, where the Supreme Court can say, I don't want to get into this. You are firing a gun from my shoulder because you're too non-courageous to take a stand on it. So the Supreme Court in some cases can't say no to the president, in some cases can say no to the president. Okay? So whenever the president refers an issue to the Supreme Court, it's written as in reference and the issue. The second is the suo motu powers of the higher courts. For example, most recently in 2021, the Supreme Court had taken a suo motu case as far as COVID management and health practices was concerned. So the case would be written as in reference COVID mismanagement issue by central government. Things like that. Okay? Now what happens here is that this is an issue with respect to the president. Okay? That is why it is called in reference. Now let's understand what is the whole in reference part. So basically, this Kerala Education Bill was passed by the State Legislative Assembly of Kerala and then was sent to the Governor of Kerala for signature. Now, the governor can either say yes, can either say no, can also return the bill and ask them to reconsider, and the governor can also refer the bill, refer it to the president, or it's technically called reserve for the president. And that's what the governor did. The bill was referred to the president referred it to the Supreme Court, and that is how the case in reference Kerala Education Bill happened. Okay? So this is how it happened. This is why it's called in reference the Kerala Education Bill. Now, let's understand what happened. Let's understand what is it that we are referring to. Is everybody okay with this? Because this is slightly complicated. All okay? Good. So basically, simple. Again, while this concerned SC/ST, this was about certain special provisions under Articles 29 and 30, the right of minority institutions, and we know there can be religious minorities and linguistic minorities, right? What was basically happening were that, and this is actually a very detailed story, and you don't have to worry about it too much. Basic issue was, this bill, which was introduced in the Kerala Assembly, wanted to give certain protections to a certain set of institutions, wanted to give a certain set of protections to, thank you Varun, ठीक है, to a certain set of institutions. The problem was that there were massive malpractices in private educational institutions in Kerala. There were issues with the syllabus, there were issues with the pay structures. A lot of investment in education was happening primarily in the Christian educational front in Kerala. And therefore, basically what the problems were, these political outfits and these religious outfits, they were all coming together, and there were a lot of political tussle. So in 1957, the Communist Party of India had the government in Kerala. In 1957, the Communist Party, the CPI, had government in Kerala. And the Congress had partnered at that point of time with the Syrian Christian Church to sort of make a political alliance of sorts and raise questions against the government. What this bill basically wanted to do is that it wanted to regulate the appointment of teachers, it wanted to regulate the kind of salaries that had to be given, and all of this had to be done. And the bill said that these teachers are going to be paid through the treasury and all of those things, right? The Supreme Court, of course, ultimately rejected the bill, said that you cannot regulate the conditions of the rights of minority institutions, and under directive principles, it does not help you to transform society as such. Now, what the Supreme Court said here was very simple. Said, what are you fighting about? All fundamental rights are still going to be supreme and over and above all directive principles, but try and not fight. I understand that you want to make the country better. You want to regulate education better. If you see, that's exactly what your directive principles are about. If you see, these are what your directive principles are all about. They want to make the country better. Now, I understand you want to make the country better. You want to improve the standards of education. I get all of those things. Great, fantastic. Please do so. But not at the cost of fundamental rights. Not at the cost of fundamental rights. And that is why the Supreme Court thereby declared this bill to be illegal and said, no, all fundamental rights are still superseding directive principles, and try as much as possible to reconcile. Try as much as possible to reconcile them. Use a principle or a doctrine called the doctrine of harmonious construction. The doctrine of harmonious construction. Okay. And try to work with both of them in coordination with each other. It should never be fundamental rights versus directive principles. It should be fundamental rights and directive principles. Because while one is giving you political democracy, The other is giving you socio-economic democracy. And that is something we must strive for. That is something we must try and achieve as far as the country is concerned, as far as all of us are concerned. Right? So these were the two basic developments that happened for a very long time. Right? Are we clear on this? Okay. Now, simple as this. Now comes the Keswananda Bharati story. Life was going on as it is, nobody would care, and we would then remember the Golaknath case. Yes? Do we remember the Golaknath case? Yes, the Golaknath case, 1967. In the Golaknath case, the Supreme Court very clearly said the Parliament can't change any fundamental right. Isn't that what they said? And we all know how furious the government had gotten. We all know how furious the government had gotten. And we remember the 24th Amendment and the 29th Amendment, right? But then the government in 1971 used their brains. Used their brains just a tiny little bit. Used their brains just a tiny little bit. They said, fine, we might be losing the war on fundamental rights, but we will not lose the war on fundamental rights versus directive principles. So you may remember there was the 24th Amendment and the 29th Amendment of 1971. We had discussed this. There was the 24th and the 29th Constitutional Amendment of 1971. Right? It is in the year 1971 itself, the government also passed the 25th Constitutional Amendment of 1971. And here, it was a masterstroke. It was a legal masterstroke. In this, they added a provision to Article 31. They added something to Article 31 and Article 31C. They added this, and please understand this. They amended Article 31. They added one more part called Article 31C, and they said, two directive principles of state policy are going to be superior than three fundamental rights. Trying to counter Golaknath, trying to counter Kerala education, trying to counter what is called your state of Madras. These two directive principles that we are talking about are Articles 39B and Articles 39C. They are going to be greater than 14, 19 and 31. Now, if you remember yesterday's class, these three articles sound very familiar because it is these three articles that Golaknath and Sajjan Singh and Shankari Prasad were constantly badgering the government against in the Supreme Court because these were relating to land reforms. So, they said, अगर एक तरफ से तो वार हो ही रहा है, अब हम दूसरी तरफ से वार करेंगे. We'll use the 24th and the 29th Amendment to keep strengthening our position on property. And then we're going to use the 25th Amendment कि अब directive principle की आड़ से भी हम वार करना शुरू करेंगे. Understood this? Now let me tell you how open-ended 39B and C are. What basically this means is, if the government does anything to implement Articles 39B and C, if the government does anything to implement Articles 39B and C, and your only objection to this, your only objection to 39B and C is the fact that it is violating 14, 19 and 31, then that objection is not valid. then that objection is not going to stand a single day in court. It's not going to even see the face of a good decision. The courts cannot get into this because 39B and 39C are going to be superior than 14, 19 and 31. They're going to be superior than 14, 19 and 31. Do we understand this? ये क्लियर हुआ? ये समझ में आ रहा है? मतलब सीधा छक्का ही मार दिया कि these two directive principles are greater than these two fundamental rights and no judicial review of any of this outside the court of the Supreme, outside the scope of the Supreme Court. ठीक है? Now you see how open-ended Articles 39B and C are. Now you see how open-ended Articles 39B and C are. Okay? See. Certain principles of policy that must be followed by the state. The state shall, in particular, direct its policy towards securing. The state shall, in particular, yes, direct its policy towards securing. All citizens, men and women, shall have a right to adequate means of living. ठीक है, वो तो A है. Let's focus here. Let's focus here. 39B and 39C. Okay? The ownership and the control of material resources of the community are so distributed so as to subserve the common good. समाज की चीजों को उस तरह से डिस्ट्रीब्यूट किया जाए जिससे सबका भला हो, सिर्फ एक इंसान का नहीं. ठीक है? दूसरा, the operation of the economic system does not result in the concentration of wealth and means of production to the common detriment. The operation of the economic system does not result in the concentration of wealth and the means of economic production. Production to the common detriment. Basically says कि भाई आप कम लोगों के पास ज़्यादा से ज़्यादा आर्थिक सामग्री नहीं रख सकते और जो कमाने का साधन है, जो प्रोडक्शन का साधन है, वो भी सबकी भलाई की तरह इस्तेमाल होना चाहिए. ठीक है? ध्यान से देखिए, इसमें कुछ छुपा हुआ है. ओनरशिप एंड कंट्रोल ऑफ मटीरियल रिसोर्सेज. इस देश की सबसे इंपॉर्टेंट मटीरियल रिसोर्स तो लैंड है. इस देश की सबसे इंपॉर्टेंट और सबसे जरूरी मटीरियल रिसोर्स तो लैंड है. तो आपने यहां छक्का मार दिया. सीधा बॉल स्टेडियम के बाहर. आपको उस गवर्नमेंट के लीगल एडवाइजर्स की दाद तो देनी पड़ेगी कि भाई कुछ तो कमाल किया है. ऐसा नहीं है, कुछ तो कमाल किया है. करेक्ट? अंडरस्टूड दिस? पक्का? एनी प्रॉब्लम सो फार? ये समझ में आ रहा है? यस. ठीक है. अब आप में से कुछ लोगों का बहुत क्लियर सवाल होना चाहिए, सर इनको ये चमका कैसे? ये आइडिया आया क्यों? ये आइडिया आया क्यों? यहां यहां क्या हो रहा था, क्या दिमाग खराब हो रहा है गवर्नमेंट का? यस, what is it that is happening? See, the government had taken a massive hit. The government had taken a massive hit after Golaknath. Oh, ईगो है भाई. गवर्नमेंट ने कहा ठीक है, अगर घी सीधी उंगली से नहीं निकल सकेगा तो उंगली को हमको टेढ़ा करना पड़ेगा, तो हम टेढ़ा कर रहे हैं. Sorry, 1969 हमने इस देश में सारे के सारे ठीक है बैंक बंद कर दिए, सारे के सारे प्राइवेट बैंक बंद कर दिए. In 1969, the government came up with the policy of nationalization of banks. Nationalization of banks. Nationalization of banks. प्राइवेट ऑफिसेस, प्राइवेट बैंक्स बंद कर दिए. अच्छा लगे बुरा लगे, क्यों बंद करें? इसलिए बंद करें. Ownership and control of material resources, operation of the economic system. Banks are an instrument of the economic system. Because there were so many private banks, people were not able to open accounts. Everybody was out of the formal financial system. So the Prime Minister of India in 1969, very clearly, the Prime Minister of India of 1969 very clearly went up to the people and said, हम आपके साथ ये नहीं होने पड़ेंगे, हम आपके साथ ये नहीं होने देंगे, चाहे कुछ भी हो जाए. और आप भी जानते हैं कि उस समय हमारे देश की प्रधानमंत्री और कोई नहीं, श्रीमती इंदिरा गांधी थी. उन्होंने कहा कि हर आम इंसान को बैंक में खाता खोलने का हक होना चाहिए. Everybody should have the right to open an account in a private bank, in a bank. And if private banks don't allow you to do so, we're going to shut them down. We are going to own all private banks. The government got into a massive socialistic nationalization phase. ठीक है, 1969. This is a direct violation of the fundamental right to profession. Article 19, subclause A, subclause G. 19(1)G. If अरे मेरे को प्राइवेट बैंक चलाने का हक है, अब आप कह रहे हो आप चला ही नहीं सकते. क्यों? क्योंकि आपको देश भर में सबको बैंक में अकाउंट खुलवाना है. So somewhere nationalization is also a conflict between fundamental rights and directive principles. All right? Fundamental banks, right, of course, is nothing but a concept of conflict between directive principles and supreme and fundamental rights. Now, R.C. Cooper sahab, obviously, Parsi owned basic major banks. R.C. Cooper challenged this. In the R.C. Cooper case, the Supreme Court struck down your bank nationalizations. R.C. Cooper versus Union of India struck down these private banks. Okay? All right? Supreme Court said the Parliament has the right to nationalize banks. No problem at all. But this particular nationalization is wrong. ठीक है, चलो खैर, सिर्फ यही नहीं किया. 1970 में we also abolished something called privy purses. Privy purses. Now what are privy purses? हमारे जो वो हैं, जो हमारे प्रिंसली स्टेट्स के जो बचे कुचे थे, सरकार ने उनको प्रॉमिस करा हर महीना इतना पैसा अकाउंट में पहुंच जाएगा, आप टेंशन मत लो, इतना हर महीने इतना पैसा अकाउंट पे पहुंच जाएगा, कोई टेंशन की बात ही नहीं है, बढ़िया चल रहा है, कोई टेंशन ही नहीं है, बढ़िया चल रहा है, हर महीने इतना पैसा अकाउंट में पहुंच जाएगा, कोई टेंशन ही नहीं है बाबा आपको। वो पैसा रोक दिया। वी अबॉलिश्ड प्रिवी पर्सेस। ऑफ कोर्स अब जिनके साथ हुआ है उन्हीं को दिक्कत होगी। यू वुड हैव हर्ड ऑफ दिस नेम कॉल्ड माधव राव सिंधिया। माधव राव सिंधिया challenged this case and the Supreme Court struck down privy purses कि ये जो आपने जो इनको पैसा देना बंद करा है, इनको देना शुरू करिए। The Supreme Court abolished privy purses. Okay, abolished it. ठीक है। And then the Supreme Court abolished it in the Sindhya case. और हमको और गुस्सा आया, हमने 26th Amendment 1971 से इसको दोबारा लागू कर दिया। We again implemented the abolition on privy purses. हमने कहा अगर इतनी ही दिक्कत है तो बात को जड़ से खत्म करते हैं। जड़ से कहां से शुरू हो रहा है ये सब? सर यहां से सर। इकोनॉमिक सिस्टम, concentration of wealth. Why should the princely states and the royalties of the country enjoy wealth? क्यों मैं उनको फालतू में पैसा देता रहूं? क्या मिलेगा मुझे फालतू में पैसा देके? क्यों मैं लैंड को कुछ लोगों के हाथ में रखूं? क्यों मैं बैंक्स कुछ लोगों के हाथ में हो? 39 BNC के तहत बैंक नेशनलाइजेशन, अबॉलिशन ऑफ प्रिवी पर्सेस, और यही हम अब लैंड रिफॉर्म में भी इस्तेमाल करेंगे। ठीक है, अंडरस्टूड, क्लियर? बस इसके बाद क्या था? इसके बाद था आपका मेरा सबका प्यारा केशवानंद भारती वर्सेस स्टेट ऑफ केरला in 1973. केशवानंद भारती वर्सेस स्टेट ऑफ केरला in 1973. अब केशु भाई ने क्या कहा? सुप्रीम कोर्ट ने कहा सब क्या चल रहा है, क्या कर रहे हो, बात बात पे लड़ते रहते हो तुम लोग। ठीक है, एक काम करते हैं, ठीक, कोई इशू नहीं है। 39B and 39C greater than 14/1931, no problem at all. बट ये जो नो जुडिशियल रिव्यू बोला है ना, ये नहीं चलेगा। सो 31C को पार्शियली स्ट्राइक डाउन करा। ये वाला पार्ट वाज ओके, दिस वाला पार्ट वाज नॉट। They said no, judicial review will be there and the courts will look into this और हम डिसाइड करेंगे क्या सही है क्या नहीं है, बट ये कोर्ट के दायरे से आप बाहर नहीं रख सकते। आपको जो करना है करिए। मैं समझ सकता हूँ यूटिलिटेरियनिज्म है, मैं समझ सकता हूँ ग्रेटर गुड है, दैट यू वांट टू मेक द लाइव्स ऑफ द पीपल बेटर। उसके लिए एक दो की राइट जाती है तो जाने दो। आई अंडरस्टैंड, नो प्रॉब्लम एट ऑल। बट ये डिसाइड मैं करूंगा, आप नहीं। मैं कौन? सुप्रीम कोर्ट। ठीक है, मैं कौन? सुप्रीम कोर्ट। क्लियर ऑन दिस? अंडरस्टूड? यस। सो दिस वाज डन। यहां तक कहानी ठीक है, कोई प्रॉब्लम ही नहीं है, राइट? कहानी को थोड़ा और आगे बढ़ाते। ठीक है, कहानी को और थोड़ा आगे बढ़ाते हैं। चलिए, इंटरवल का टाइम हो गया है, यू कैन रिकंसाइल योर नोट्स। ठीक है, टेक अ 5 minute break, reconcile this and then we'll continue. All right. तो अब तक क्या हुआ? Little bit of a recap. Something very simple, that in Keswananda versus Kerala in 1973, Supreme Court said no problem, 39B and 39C are 39B and 39C are greater than 14, 19, 31. They basically had partially struck down 31C and they said जो पहले कह रहे थे जुडिशियल रिव्यू नहीं हो पाएगा, बिल्कुल हो पाएगा. So judicial review or the Supreme Court can get into this and decide on a case by case basis. Done. Emergency का आलम आने वाला है, right? Emergency का आलम आने वाला है. And then comes the 42nd Constitutional Amendment 1976. You would remember this from Keswananda Bharati as well. Yes, in the 42nd Amendment, they said, लोगों का कर्तव्य है. We also added our fundamental duties. And here, उन्होंने कहा ठीक है बेटा, करो judicial review. But in 31C they said, not just these two, all directive principles greater than 14, 19 and 31. All directive principles greater than 14, 19 and 31. And you will remember from Keswananda Bharati, they amended Article 368 and said the Parliament can make any change to a fundamental right. It does not apply. The 13 clause 2 exceptions don't apply to 368, and the Parliament can change any fundamental right. Overruling Golaknath and so on and so forth. खत्म करते हैं ये ड्रामा ही खत्म करते हैं. इमरजेंसी का समय खत्म हुआ, जनता पार्टी की गवर्नमेंट आई, एंड देन द 44th Constitutional Amendment of 1978, wherein they removed Article 31. 31 ABC अभी भी है, 31 हटाया है. So right to property removed as a fundamental right. इसका मतलब this is the current legal status. और इसकी आड़ में government started nationalizing. They passed nationalization acts, industrial acts, and Minerva Mills, the first case which had nothing to do with property, came into being. Minerva Mills versus Union of India in 1980. Minerva Mills versus Union of India 1980. Okay, versus Union of India in 1980. So it was nothing. Minerva Mills was a textile mill in Bangalore, which was nationalized by the government of India, saying that the textile mill in Bangalore is not functioning as per the right production and capacity. You will no longer be able to own it privately. The government is now going to own the textile mill in Bangalore. The owners of Minerva Mill filed a case in the Supreme Court कि ऐसे कैसे. Government ने कहा भाई all directive principles. So what? You have the right to own a textile mill. So what? We also have the right to prevent concentration of wealth. We have the right to ensure economic activities for common good. So under these directive principles, and your only problem is your freedom of profession, बाहर में गया freedom of profession, बाहर में गया freedom of work. यही है और यही होगा. So in Minerva Mills, right? They overturned it. In Minerva Mills उन्होंने कहा चलो एक काम करते हैं, ठीक है? Let's go back, और ये नहीं होगा. We go back to the Kesananda Bharati position that 39B and 39C are greater than 14 and 19, are superior to 14 and 19. 31 doesn't exist anymore. This can be looked into by the court's judicial review on a case-to-case basis. और ये जो तुम्हारा लास्ट अटेम्प्ट था ना कोशिश करने की कि बस किसी तरह the parliament can make any change to a fundamental right, because 44th amendment was basically the 42nd amendment, this part wanted to basically overrule Kesananda Bharati. इसको हटा दिया. They removed the 368 clause and they declared it unconstitutional, that no, under no circumstances the parliament can make any change to anything in the constitution which violates basic structure. ठीक है? Even today constitutional amendments are not law. वो मुझे समझ में आ रहा है as per 13 clause 2. But you cannot make any amendment to the constitution which violates the basic structure. So Minerva Mills, ladies and gentlemen, becomes the very last case where the government tried to make an effort for parliamentary supremacy over the constitution. It was the very last case. And it is actually Minerva Mills that marks the beginning of proper judicial supremacy. It is one of the cases that India has forgotten. But this case is an extremely underrated case, but an extremely important case. As important as Kesananda Bharati, if not more. And this laid the firm ground and the firm foundation of what is called the doctrine of harmonious construction. That as much as possible, try to balance fundamental rights and directive principles. For example, you have the fundamental right to freedom of religion under Article 25. But you also have uniform civil code under directive principles. You can see this clearly here. You have something called Uniform Civil Code. Uniform Civil Code is trying to come up with common principles that could be applied across all religions. It's right here, Article 44. So, when you are trying to implement Article 44, don't violate the freedom of religion. Balance it with the Uniform Civil Code. That is what was meant by Minerva Mills. अब इन दो कहानियों को जोड़ो तो ये देश बनता है. इन दो कहानियों को जोड़ो तो ये देश बनता है. ठीक है? अब इन दो स्टोरीज को मैं जोड़ के दिखाता हूं. इन दो स्टोरीज को मैं जोड़ के दिखाता हूं. ठीक है? वेरी सिंपल. मैं जोड़ के दिखाता हूं. ठीक है? क्लियर? So story number 1, we discussed this yesterday on fundamental rights. Starts with land reform, then the first constitutional amendment of 1951, then Shankari Prasad, (1951). Government gets overconfident, 17th Constitutional Amendment, 1964. The red plot happens, Golaknath of 1967. यहां से शुरू करते हैं. तो चंपक्कम केस of 1951, the Kerala case, in reference Kerala case of 1958, 1961 यहाँ हुआ, and then comes your bombardment of constitutional amendments. 24th Amendment 1971, 25th Amendment 1971, 26th Amendment 1971, and 29th Amendment 1971. Then Keswananda Bharti versus Kerala, 1973. Then 42nd Constitutional Amendment, 1976. 44th Constitutional Amendment, 1978. Then Minerva Mills versus Union of India, 1980. And most recently, I.R. Coelho versus State of Tamil Nadu, 2007. Yes, इसके बीच में we had the emergency, which led to the 39th Constitutional Amendment. Yaha we had bank nationalization and abolition of privy purses. अब कहानी क्लियर हुई. यहां से शुरू, it all merges here. Correct? So this is a FR DPSP case. This is an FR DPSP case. Right? Everything else from here, from Golaknath till about Minerva Mills, is both fundamental rights and directive principles. I.R. Coelho is just about fundamental rights, and these cases are just about fundamental rights. This is the first story, and this is the second story of fundamental rights versus directive principles. And that is how the two doctrines, first, the doctrine of basic structure, and the second is the doctrine of harmonious construction. ठीक है? If Vaman Rao case was important, Vaibhav, I would have told you, don't tell me what I need to teach you. Okay? So don't worry about it. Don't do random Google searches and tell me what I need to do. Okay? If the Vaman Rao case was important, as far as this evolution is concerned, I would have taught you the same. So relax. Vaman Rao case is about the 9th schedule. About it basically said that anything before Kesananda Bharti would be immune from judicial review, which was overruled in IR Koholo. So it's fine. The present status is a very simple one. Constitutional amendments are not law. So can you make a constitutional amendment that violates a fundamental right? Yes, you can. As long as it doesn't violate basic structure. That is the law today. Okay? R.C. Cooper is the bank nationalization case. The Supreme Court said that they declared the bank nationalization is unconstitutional, but they said in the future if the parliament wants to do so, it's okay, they can. But this particular instance is unconstitutional. ठीक है? Done. Yes. गुड. तो अब हमारा लेयर 2 का एक टॉपिक खत्म हो गया. अब बस एक ही टॉपिक बचता है, एप्लीकेशंस of rights, directive principles and duties. It is going to take us 1 day to finish it properly, about 2.5 hours or so, right? So that is something which we have to study. वो हम कल करेंगे. अब आपके जो भी डाउट्स हैं ना, आप मुझसे पूछ सकते हैं, क्योंकि मैंने काफ़ी दिनों से आपके डाउट्स नहीं लिए हैं. Current fundamental rights can be changed, of course. If you're asking for what your current status is, this is very specific what your current status is. कि आज क्या है? First, can fundamental rights be changed? Yes. Can all fundamental rights be changed? Yes. Does the word law in Article 13 Clause 2 include constitutional amendments? No. So obviously a fundamental right has to be done through a constitutional amendment. A change has to be through a constitutional amendment. You can change it. Any change to a fundamental right can't violate the doctrine of basic structure. ये है. And of course 39B and 39C are greater than 14 and 19 if these are your only FR violations. And as far as the 9th schedule is concerned, anything before or after, anything basically before after हटा दो, anything in the 9th schedule can be judicially reviewed if it violates basic structure. मोस्ट वेलकम निशांत। ठीक है, ये अब आज का स्टेटस है। दिस इज द लॉ एज इट इज टुडे। ठीक है, वैभव बेटा वामन राव के केस में मत जाओ, एग्जाम के लिए रेलिवेंट नहीं है। लॉ ऑप्शनल होता तो हम जरूर बात करते इसके बारे में। यस सौरव, दैट इज व्हाट वी डिस्कस्ड। डीबीएस इज सुप्रीम। सुप्रीम कोर्ट ने जो बोला वो बोला, सही है, नहीं है तो नहीं है, क्या कर सकते हैं। Basic structure is a set of principles evolved by the Supreme Court which cannot be violated by any action by any entity in the country. ऋषभ, ये कहाँ लिखा आर्टिकल 21 बेसिक स्ट्रक्चर है? कोई आर्टिकल का नाम लिखा ही नहीं है, प्रिंसिपल्स लिखे हैं। Mayank, the rights of people who were administering these minority education institutions, the governments were over-regulating it. No, toll booths they aren't. Abhinav, this is the present status of the doctrine of harmonious construction, no? All right. A legal right is a right which is in any other law which is not the Constitution. A fundamental right is a right under Part 3 of the Constitution. A constitutional right is a right in the Constitution but not under Part 3. Reservation is not basic structure. Absolutely. Navya. Divyansh, that is the case, was inherently a problem. Suo motu powers, both Supreme Court and High Court. Thank you, Queen. Respect to Articles 14 and 19, सुना करो पूरी बात. That constitutional amendments are not included in the definition of law as per Article 13, Clause 2. Made by the Supreme Court through various judgments. Supreme Court through various judgments. Judicial review was in Sampath Kumar, parliamentary democracy was in some other case. I'll give you a list of those. Court decides on a case-by-case basis. ठीक है. So nowadays, yes. This is IR Coelho, no? The last point. Of course, we added Article 21A. It does not violate basic structure. सुप्रीम कोर्ट में केस पहुंचेगा तो वो डिसाइड करेंगे। Yes, Varun, I'll talk to you. Yes, Naman, we are done with this. We'll do with the issues tomorrow. I'll give you a list of everything which is basic structure and the Supreme Court judgment that they saw. Yes, Akash, it's judicial innovation. Yes, Nishan, that is what I've given you in the notes also. Yes, Minerva Mills is something you must definitely mention. Thank you, Saru. ठीक है, डन, सॉर्टेड, परफेक्ट। तो चलो भाई, क्लियर हो गया मामला। ओके, थैंक यू। थैंक यू सदा भाई, हो गया भाई, हो गया। थैंक यू अमन, थैंक यू अमन। Of course, constitutional amendments can be judicially reviewed. Law is only with the context of fundamental rights, na Article 13, Clause 2. Of course, more fundamental rights can be added. Naman, this is the IR Kohilo case. ड्राइव में जाइए, नोट्स मिल जाएंगे आपको। मेंस फोल्डर क्लिक करिए, थीम नंबर 1 क्लिक करिए, सब कुछ दिया है मैंने वहां पे पहले से।